Um, Continuing with the amendments, we're now at Amendment 7. And here we shift out of the criminal law into the civil law. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. Now, it should be commented that we no longer absolutely guarantee this right, although most states permit jury trials of small juries, even in small claims cases. Um, it's kind of gone by the wayside, if you will. The federal court jurisdictional limit now is that you get a federal court in amounts in controversy in excess of $75,000, which would give you some idea of the inflation from what are we at 1783 all the way to I believe that law was passed in the 1990s and hasn't really been updated, but it's a big enough number that it doesn't necessarily need to be updated for a long time. To me, the power and the part that's oftentimes sort of ignored is that no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. And this is meant to be very careful about overturning jury verdicts. This is a caution to judges. Jurors in our system are very powerful people. And if you think about, if somebody's telling a lie and 20 people are watching it, there's a chance that you'll fool 18 of those people, but 2 of them will discover, that was a lie and here's why. And they'll be able to explain to the other people and convince them or not. It's not always correct. But the power of those 12 people sitting in judgment it is very great in our system, because if we compare it to an individual judge who may have a docket of 400 or 500 cases, or maybe 80 or 90, but tends to hear things over and over and over and over. In the course of a 30, 35-year judicial or legal career, one can get a little bit jaundiced, whereas a juror comes to this ordinarily with a very fresh face. If you talk to people who've been on a lot of juries, they will have done it 3 times. You talk to a judge or a lawyer who's done something, and they will have done it thousands of times. And so, while you get discernment by continuous exposure, one of the great features of our inherited British common law is that we have a great trust in the populace, that we have a trust in people who ordinarily want to do the right thing. So the part about rules of the common law are, for instance, if there's absolutely not a shred of evidence to support the jury's decision, then it should be overturned. But if there's a little tiny, what sometimes is called a scintilla or more than a scintilla of evidence supporting the verdict, uphold it. Anyway, I probably went a little long there. All right, so let's, been having some internet issues and I had to cut off on another. So now we're looking at Amendment 8. And this is the excess bail, excess fines, nor cruel and unusual punishments inflicted. Oftentimes this is cited in capital cases, that is the death penalty. I'm not an expert in this, but generally a simple reading is, if we go back to the time when this came up, most felonies ended in beheading, stoning, or hanging. Cruel and unusual punishments is not well defined here, and I think it maybe is left open by the framers for this to be a living component in the prosecution. They could see maybe that the stocks and things like that were beginning to go out. We had not yet reached the guillotine phase of the French Revolution, but this is a bulwark, if you will, against that sort of challenge where, we may have mobs that run amok and decide, let's hang everybody for X, Y, and Z. And then this is, the Ninth Amendment is an interesting piece of legal work that probably just reinforces a beautiful Latin phrase, inclusio unius, exclusio alterius. My kids are always correcting my Latin pronunciations, but that essentially says if we include something in a list, we exclude other rights. But here we go. Here, what we're saying is the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The framers, fully knowing that inclusio unius, exclusio alterius is the standard rule of statutory interpretation. For instance, if we are regulating horses, everything we list is only about horses. It is not also about pigs. That is, if we put in a list that we're going to regulate cars and light trucks, well, by extension, because we did not put into it the tractors that pull 18-wheelers, those are not light trucks, we are not regulating them. Well, here we want to make sure that because we've given all these people all these rights, the government or anyone acting on behalf of the government cannot come back and say, oh, wait, your right wasn't listed there, therefore it's not preserved. Now, I'm going to struggle to come up with some examples here, but it's maybe some of a person in their castle kind of thinking. Let's see what the comments are. Is that yes, the unenumerated rights, and maybe that's life, liberty, and the pursuit of happiness that's found in the Declaration of Independence. Anyway, you might want to take a long time in reading about Jefferson. There's a bunch of very interesting pieces about him and the Declaration of Independence and the language used there. But essentially, this ends it for us. One more peek at the 10th Amendment. The powers not delegated by the United States, delegated to the United States by the Constitution, nor prohibited by it to the states. Okay, so the powers not prohibited, I believe, by the Constitution as against the states, i.e. the powers not given under Article 1, Section 8 or Article 1, Sections 9 and 10, as we looked at earlier. Everything else is reserved to the states, and the key phrase to me, or to the people. Now, this can sometimes lead to conspiracy theorists that the government is all about seizing more and more and more and more and more and more power. But it is that we should, as we walk through our lives in a free society, be wary of giving power to the government, because once given, it is rarely surrendered. I want to peek at the 11th Amendment, and that is, I hope you can read it yourself. I'm not going to comment. Thanks.